are you skirting the rules, or is? Yeah, probably not, because the test is interconnection with the PSTN such that you can send and receive calls to and from the PSTN. So if all you're doing is buying Skype out, you don't have the ability to send to and from the PSTN, or at least the Skype service doesn't offer that capability.
If I buy Skype in and I buy Skype out and I buy one of those devices that hooks up to my router, so it's an IP connected device, what is it that Skype argues under that condition that they're not interconnected with certified?
I don't know that they've ever had to make that argument before the FCC. I suspect what they would say is these are two separate services. And the way the FCC has defined its regulations is that both the calls to and from the PSTN must be offered in the same service arrangement. That you can get there functionally by buying both services, I don't think the FCC anticipated that. So it might come down to a technical argument.
Let's take Skype out of this so show insult or perceived to company. Let's say XYZ VoIP company. You make a call, you're originating off your PC, it's your IP, but you're calling, Farmer John in Iowa on a rural telco. Is XYZ going to pay access charges to that rural telco in Iowa for that call?
It depends. It depends upon whether or not they use some sort of CLEC partner or some other entity to get to the rural telco.
Yeah, but is somebody going to pay that rural telco for?
Certainly, from the rural telco's perspective, yes. Somebody would, somebody should. But I've talked about some of the access avoidance schemes, the phantom traffic issue. So it depends upon whether or not those types of arrangements were put in place.
I meant from a legal point of view, somebody ought to pay them for, they've incurred costs to receive that call. So just because it originated off a router somewhere in somebody's house shouldn't be immaterial to the cost that's occurred for this telephone.
Well, and certainly if you take the perspective, sort of a legacy perspective, that these rules were put in place when the industry was much more static. There was a set number of players. We knew who they were. We knew what their costs were. And there was some rationale for allowing them.
I'm not saying they necessarily deserve 20 cents a call for it, but again, they are incurring some cost. Now, what that access rate ought to be is something to be decided on a cost study basis, but the fact that somebody could just cause me to incur network costs and not compensate me for it, kind of flies in the face of how this is all set up.
Well, and certainly the many rural telcos have made those arguments, and a number of the incumbent LECs have.
I'm always a big fan of it, but I can see in this case that, just because somebody originated the call on a Wi-Fi handset in their house means that they're somehow exempt from, paying money as opposed to, the old rotary phone in the basement.
Yeah, a lot of people have the same concerns.
Doesn't the rural telco still receive compensation at a far lower rate because it's designated as a local call as opposed to an interstate call?
Absolutely, yes.
Okay, so, I guess this just goes back to the way they set it up originally. I don't see how, as a rural telco, their cost to terminate a call would vary at all, regardless of where it was originated across town on another carrier or across the country on another carrier. They only carried it, their switch to the customer. How is the cost, their actual cost, any different? It's not.
It's not.
It's not. So, realistically, if we were doing this again, there should be an access charge, period. And then the entire issue goes away. However, you can't, I'm assuming, the biggest problem is you can't change the model because all these people have built their entire businesses based upon it being one way. You can't change it overnight. The whole thing falls.
Yeah, that's the inherent problem. There's these forces at play who have these revenue streams that, as you said, have been receiving them for decades.
And if you're Vonage arguing this in front of the FCC, you're going to say, tell me how the rural telco is paying any more to terminate my call as it is to terminate local call.
Absolutely.
No argument against it, so you go in circles forever.
Right.
But it also shouldn't be free necessarily.
It's not free. They pay the local.
Which is why a lot of people have suggested a unified rate, right, removing the distinctions between long distance, local, international, and
they may not be paying if they sent it out as family traffic without any jurisdiction.
Or with anything at all, true, yeah.
right, right. This sort of takes us to the next slide, and that is, as we just noted, the rural telecom companies have many supporters in Congress, and they are able to leverage their political support in Congress very well at the FCC and other forums in Washington. But as I noted earlier, the decision to cap the Universal Service High Cost Fund, although not on a lot of people's radar, really could signal the beginning of some significant reforms. And the question is, at what cost to interconnected VoIP providers and the voice peering industry generally? If the FCC did move towards some comprehensive intercarrier compensation reform, it seems likely that they would bring in the VoIP providers within the compensation regime. They've signaled their willingness to do so with respect to universal service, 911, number porting, a number of other regulations. So bringing interconnected VoIP within the compensation regime is not too hard to imagine. And what that regulation might look like, I suspect that they would affirmatively require certain call signaling parameters be passed with all voice calls. And again, they would be subject to some form of terminating access, hopefully at a single, unified, and very low rate. Again, the rural telcos and the incumbents will push very hard to make sure that any traffic that touches their network, they receive compensation for. And indeed, in a recent FCC decision, the FCC noted that distinction and said, with respect to intercarrier compensation, when you touch the PSTN, you do have some obligations with respect to the costs incurred by those terminating carriers. There was speculation 4, 5, 6 years ago that the FCC might try to move the entire regime to a bill and keep standard. But I think the lesson from the ISP-bound traffic rate decision and the FCC's inability to finally answer that question suggests that bill and keep is likely not going to be a long-term component of any intercarrier compensation reform. Which means that a bill and keep or a settlement-free peering arrangement really will only be available through pure peering arrangements like the stealth exchange, and that when you're touching the regulated telecoms, there will be some cost associated with terminating that traffic. And the question will be how those costs are assessed, distributed, and ultimately absorbed, which of course will be a very contentious debate. So, any questions?
Is it, this is kind of a crystal ball sort of question, but would voice over IP services still not really be defined one way or the other, information and telecom? Taking the course of action to not treat it as telecom and not collect all the associated taxes and whatnot, is there any likelihood or possibility that the states would successfully, let's say it does get eventually classified as a telecom, the states now have 10 years of back litigation possibilities to go after all the voice over IP providers that didn't know what to do, or and we're obviously not going to be billing our customers for that stuff, or is everybody just hoping they're not the ones that get the crosshair?
Yeah, I think it's unlikely that there would be retroactive liability. Right, as long as when the states affirmatively assert their jurisdiction, and assuming there's no litigation following that action, you comply with the rules as said at that time. I mean, there are a couple of states that are moving towards that, Missouri being one of them. Cable companies that offer voice over their networks have been a particular target, and it's likely that others will follow Missouri and begin to slowly, incrementally begin to assert their jurisdiction. And So, you know, the current regime where the feds regulate some aspects and the states regulate other aspects of telecommunications market will likely be mirrored in the voice market in the future to some extent. All right, thank you.